Hi, everybody. Aaron Wudrick here. I'm the Director of the Domestic Policy Program at the Macdonald-Laurier Institute. Welcome to the vodcast today. Very pleased today to be joined by Malcolm Lavoie, Associate Professor in the Faculty of Law at the University of Alberta, and the author of a great new book entitled Trade and Commerce, Canada's Economic Constitution. Malcolm, thanks so much for joining us today to talk about your book.
Thanks so much for having me. It's a pleasure to be here.
Yeah, so I guess the obvious question first is what sort of stimulated your interest to write on this topic? A lot of people, when they think about the Constitution, they're not thinking about it from the perspective of it having an economic vision.
Yeah.
So what was sort of your inspiration behind writing this?
Yeah, that's a great question. So as you alluded to, the book is about the Constitution and the economy. In particular, I argue there's an economic vision underlying the Constitution, commitment to free interprovincial trade, economic integration, but also decentralized decision making on economic issues. And the motivation to write it really stems from a case called RV Como. This was, some people might remember this. This was the case of
The beer case.
The beer case. Yeah, exactly. The budget-conscious beer shopper Gerard Como, who went from his home in New Brunswick to Quebec to get cheap beer, ended up getting pulled over, get a ticket, his beer confiscated, essentially for possession of out-of-province beer. He challenged this as being unconstitutional on the basis of Section 121, which essentially says goods from one province are to be admitted free into another. He was successful at trial, but unsuccessful when the case went to the Supreme Court of Canada. The Supreme Court of Canada, read Section 121, this free trade clause, in a very, let's say, permissive manner in terms of what it allows governments to do. And so I wrote an article about this case, ended up getting involved for an intervener and argued the case at the Supreme Court. And I remember sitting there during the hearing. It was clear it wasn't going well for those of us who were favoring free trade. And there was a particular interaction between Justice Malcolm Rowe from Newfoundland, who, he's a great judge, but when he's up there on the bench, you always know what he's thinking. He's very candid. And he said essentially, well, you're trying to tell us that the Constitution's committed to free interprovincial trade, but the structural provisions of the Constitution, they don't have an orientation. They're about granting authority. They're not about policies. Yeah. There's no economic policy in the Constitution. I remember sitting there and thinking, well, that's just wrong. And I clearly didn't get over it, because here I am, several years later, and I've written a book about it where I say, no, there's actually some sense to for example, the heads of power that are given to Parliament versus provincial legislatures, how the executive, legislative, and judicial branches are structured. They're oriented towards a particular vision of the Constitution.
Right. And so, I mean, that is the question I think a lot of folks would point to, is they'd say, well, are you suggesting that the Constitution has a policy preference, right? And maybe perhaps Justice Rowe's argument as well, the Constitution says nothing about policy purposes, but that's not exactly your argument, is it? I mean, it's not about a policy preference, it's about the powers that each level of governments has.
Yeah. So there are purposes, and then there are how those purposes are given effect. Right. So when you're interpreting a statute or a constitution, you're supposed to look partly to the text, but also partly to the purposes that the text is trying to achieve. And when you read through the text and you look to the time when the Constitution was enacted, one of the clear purposes of that document is to provide for free interprovincial trade, free trade among what were then the British North American colonies. This is reiterated over and over again in the Confederation debates. And then you see it, when you read through the Constitution, you see it in Section 121, which essentially says we're going to have free trade between the provinces. But you also see it in the types of powers that are allocated to the federal Parliament versus the provincial legislatures. Provincial legislatures, I argue in the book, have essentially, by default, they have jurisdiction over most economic questions under the property and civil rights power. Sort of gives them a power to govern most economic relations. But then when you look through the federal heads of power, you can think of those as exceptions to this preference for decentralization. And there's a thread that runs through those federal heads of power, which is that these tend to be matters that can't be effectively dealt with at a local level. In many cases, due to the potential for a collective action problem, that if you leave it to the provinces, they're going to pursue protectionist policies, pursue local interests, at the expense of outsiders. And so whenever you have a policy area where a provincial legislature would have the power to, say, disadvantage producers in another province, that's a head of power that typically is allocated to the federal government, including, economic relations between provinces. The interprovincial trade power, a branch of the trade and commerce power, is an underappreciated federal power, I think.
Right. Now, yeah, I mean, you also argue in this book that perhaps one of the challenges is that in recent years, the Supreme Court has adopted what you call a flexible
Mhm.
federalism, and that's at odds with the economic vision that you say the Constitution really outlines. Can you maybe explain what you mean by that?
Sure, sure. So maybe the starting point is a good starting point is the text of sections 91 and 92, which allocate most of the federal and provincial heads of power. And the word exclusive appears at least a half dozen times in section 91 and 92. The Constitution repeats to the point of redundancy that the federal and provincial heads of power are meant to be exclusive. So something given to the feds is implicitly denied to the provinces, and vice versa. And the Privy Council, when that was our final court of appeal, and even in the early days after the Supreme Court of Canada became the last court of appeal in 1949, for the first few decades, the courts kept to that. They basically tried to enforce a scheme of mutual exclusivity. However, in recent decades, that's become deeply unfashionable. And
Hmm.
there's been this move towards flexible federalism, this idea that, well, as long as there's a link, as long as the overall purpose of a statute, say, is to regulate something under provincial jurisdiction, then it's okay if it also implicit or as a secondary matter deals with a range of federal matters, and vice versa. I argue that's a problem, and that undermines some of the purposes of the economic constitution in a couple of respects. So, first of all, I argue that the Constitution is committed to local autonomy, provincial autonomy, as a presumptive matter on economic questions. And the big way in which that's protected is the idea that provincial authority is exclusive,
Hmm.
right? That you're not going to have overlapping federal authority, because when you have overlapping federal authority, there's a doctrine called paramountcy, which says that essentially where you have an inconsistency, the federal statute prevails. So the more overlap you have, the more you have a situation where provinces are subject to this supervening authority of
Right.
the feds. So exclusivity protects provincial autonomy. At the same time, though, federal heads of power are also exclusive, and that also serves a purpose, right? When you have a federal power over interprovincial trade, or you have a federal power over, say, currency, these sort of basic structural features of the economy, that's because you can't necessarily rely on local governments to regulate those matters effectively. And if you do allow for, say, provincial measures that are gumming up interprovincial trade, you have a situation where you have a cumulative effect of lots of provincial measures that together undermine the free trade that we're supposed to have among the provinces. And so it also matters that the federal heads of power are exclusive. And so I think the move towards flexible federalism is actually inconsistent with the economic vision of the Constitution. We should be getting back to a scheme of greater exclusivity that protects those federal heads of power from being gummed up by local measures that don't account for the national interest, but at the same time that protect provincial autonomy in those areas where you don't need federal authority to have effective policymaking.
Okay, I want to get to, of course, what you think, what proposals could help restore that approach. But
Mhm.
first, I'm curious as to what, in your view, what was the first case, or at what point did the court sort of change its approach? I think it's fair to say a lot of us who constitutional
Yeah.
law nerds, have seen the court sort of twist themselves into knots to try and avoid the plain meaning of words. Like you say, exclusivity appears a lot in there. That has not seemed to carry weight. Section 121 as well.
Hmm.
I think in the Como case, people sort of felt, a lot of legal observers just were head scratching how the court could interpret it the way they did. Was there a particular trend or a set of cases where you sort of saw this change in terms of adopting this flexible
Mhm.
federalism?
Yeah, it begins in the late 1980s. I don't know if it's necessarily caused by the charter. The charter, um, you know, put more of an emphasis on sort of non-economic rights.
Hmm.
I think there was also maybe a shift in judicial ideology towards wanting to take a more permissive approach to economic regulation, to sort of get the Constitution out of the way of good faith efforts by both orders of government
Sure.
to regulate the economy. And yeah, and there, I mean, there's something to that, right? You don't want to have an overly strict policing of exclusivity where you completely, render it impractical to regulate certain matters. It's hard to say regulate something under provincial jurisdiction without touching anything under federal jurisdiction. You should be allowed to have a little bit of overlap as long as it's necessary to what you're trying to achieve. But I think we've gotten past that. We've gotten beyond that towards an undue level of flexibility, and having provinces that are able to indirectly regulate interprovincial trade and create these trade barriers. And at the same time, the problem of the feds taking an overly expansive understanding of their authority. The Impact Assessment Act, which was recently at the Supreme Court of Canada, is a good example of this, where they were careful in their drafting to anchor it in a series of federal heads of power. But then they say, well, anything that's connected to those federal heads of power, anything that's connected to navigable waters or indigenous lands, we claim a power to be able to ultimately veto that project. And that's kind of what I mean by flexible federalism, where you're saying, it's not just things that are strictly necessary, say for fisheries or indigenous lands or some other federal heads of power. It's anything that's sort of more indirectly related to that. And so there's been a shift in ideology. I think it's partly that people are less likely to understand the economic purposes behind the Constitution. I think those would have been more salient, say, before the 1980s. There's just not been a lot of scholarship on some of these, on federalism, in particular economic federalism, within the world of legal scholarship in the past 3 or 4 decades. There's some, but not a whole lot, and a lot of the attention went to the Charter and other areas of constitutional law. So I think that might partly explain it.
Well, that's certainly why your book is so welcome right now, because of the lack of that. I'm curious too if you think it has anything to do with maybe a sort of the court's concern about trying to avoid political controversy. I mean, it's a lot easier for a court to say, why can't we all just get along and we'll just start splitting the difference, because that's a lot easier than the court coming down and saying, actually, no, you can't do this. Is there anything to that argument that maybe courts are just trying to take the path of least resistance here?
Yeah, maybe on some areas that's true. I mean, it's interesting, and I've never sort of thought of it this way before. But at the same time, as courts were becoming more activist in, say, their interpretation of the Charter, they sort of took a more permissive tack on federalism issues. Not in all cases. Occasionally, they'll strike a measure down on federalism grounds, but they've, as an overall tendency, adopted this much more permissive approach in federalism cases, while at the same time not hesitating to strike legislation down on Charter grounds. It'd be sort of speculating to say, what's the psychological, cause of that. But it might be, partly a greater attention to the Charter, or maybe implicitly a desire to use that political capital that they perceive themselves to have on sort of Charter-related issues as opposed to federalism issues. I'm not quite sure.
Sure, and it seems like it would almost inevitably be a one-way street there, right? Like when you have this flexible federalism, between that and the doctrine of paramountcy, it's going to mean more and more powers for the feds and less for the provinces. And that, again, in a country that's a federal country for a reason, I think sort of starts to open up other cans of worms politically. But I wanted to get to the proposals. Like, so how do we get back on track here? If we've sort of gone awry with flexible federalism, how do we get back to what the Constitution, in your view, really says? How can the court sort of take an approach and align with the true meaning of the Constitution?
Well, probably the number one sort of recommendation in terms of constitutional interpretation would be that we have to give effect to those words in sections 91 and 92 that refer to exclusivity over and over again, that say these heads of power are exclusive. If you're taking the sort of extreme flexible approach, where as long as you have some rational connection to a broader scheme within, say, provincial or federal jurisdiction, it's okay to affect the other order of government. I think that fails to give effect to this idea of exclusivity. That essentially says, as long as there's some connection to what you're supposed to be legislating on, we're going to give it a pass. And whether that connection is a strong one or a weak one. I think, specifically in terms of, legal doctrine, what we could do is we could say we're not going to, use this rational and functional connection approach. Instead, we're going to say, if you're intruding on, if you've got an ancillary measure in a federal law that's intruding on provincial jurisdiction, that measure has to be necessary to the federal purpose of your scheme. It can't just be rationally connected or functionally connected. It has to actually be necessary if you're going to have that sort of secondary aspect of the law that intrudes on provincial jurisdiction. I think that would go a long way.
Much higher bar to reach.
Yeah, you have to, and the onus would be on the enacting level of government to establish that they really do need to do this. So, if you're, say, vetoing provincial natural resources projects on the basis of their effects on fisheries, that has to actually be necessary to achieve a purpose related to fisheries. It can't just be something that's rationally connected to it, to use the example of the Impact Assessment Act. So that would go a long way. There are also aspects of this that relate to political will. So on economic matters in particular, Parliament hasn't fully exercised the powers that it could exercise to help ensure greater economic integration. There's a whole bunch of examples you could give of areas where the feds have essentially, failed to regulate harmonization where they could harmonize the laws. And so one example of that would be interprovincial trucking. So there was a Senate report a number of years ago that detailed the differences in regulations from one province to the next. In extreme cases, you have configurations that are mandatory in one province but prohibited in the next province. You have to actually change the tires or the configuration of the truck at the provincial border. There's jurisprudence that clearly establishes that interprovincial trucking is under federal jurisdiction. All the feds would have to do is enact uniform legislation for interprovincial trucking, and they could solve some of these problems. And that's just one example. You could have broader legislation too, where under the interprovincial trade power, for example, where the feds sort of mandate through legislation that there's going to be free interprovincial trade, and that requirement takes priority over any provincial measure unless that measure is necessary to achieve a provincial purpose, and sort of use paramountcy as a tool to create freer trade. And that's something the feds can, I think, arguably do unilaterally. We've been pursuing this model of federal provincial agreements where everyone commits to the principle of free trade, but then you have hundreds of pages of specific exceptions. And that's just interest group politics, right? At the local level, interest groups lobby for their own exceptions. I think it's possible for the feds to simply short circuit that and enact some of these requirements through federal legislation and not have to get the provinces on board and use paramountcy as a tool to overcome inconsistent provincial laws.
Okay, that's great. Well, this is a great book. I think a long time coming. The book is Trade and Commerce, Canada's Economic Constitution. And and you can find it on Amazon.ca and some other online retailers. I certainly encourage you to do that. I want to thank all of you for joining us. Thank you, Malcolm, for joining us, and to our viewers and listeners. We'll catch you next time.
Thanks, Aaron.